Okay, I think I'm going to get started, but other people might trickle in, that's fine. I'm Trevor Chenoweth. I'm the president of the Moot Court Board. This event is US v. Robinson, a discussion of the Hardt problem this year. This is the problem for all the first-year competitors after they opted in to continue in the competition after the LERW problems. We have a distinguished panel here to speak about this case and the really myriad issues that it presents. So first, starting from your right, Professor Griffin is a professor of law at Duke. She graduated from Stanford Law School before clerking on the Ninth Circuit and the Supreme Court of the United States for Justice O'Connor. She worked for 5 years as an assistant U.S. attorney in Chicago, and her scholarship focuses on evidence theory, constitutional criminal procedure, and federal criminal justice policy. In the middle, Professor Charles is also a professor at Duke. He graduated from the University of Michigan Law School, clerked on the Sixth Circuit. He is the founding director of the Duke Law Center on Law, Race, and Politics, and his scholarship focuses on constitutional law, election law, campaign finance, redistricting, politics, and race. And finally, Alan DuBois is the first assistant federal public defender in the Eastern District of North Carolina. He received his undergraduate degree from here at Duke before graduating from the University of Virginia School of Law. He clerked on the Fourth Circuit before joining the Federal Public Defenders and working as an appellate attorney. His office provides legal assistance to defendants in federal court who are unable to afford a lawyer to represent them. He also has faced off against then Solicitor General Elena Kagan before the Supreme Court of the United States in United States v. Comstock, and I'm told that he then saw her shortly thereafter sitting on the bench where he argued with her before. So great panel, and they can tackle a lot of the issues in the case. For those of you that haven't heard the facts of the case, didn't participate in the Hardt Cup, just quickly brief you on that. It happened in West Virginia in 2014. Police received an anonymous tip about a black man loading a gun in a 7-Eleven parking lot before leaving in a car driven by a white female. Officers then located the car in the area, pulled it over for a seatbelt violation, and asked whether the passenger, Shaquille Robinson, the defendant in this case, was carrying a weapon. When he didn't answer that question, he was frisked, which is otherwise known as a pat-down, and his gun was found, and he was convicted of being a felon in possession of a firearm, which is a federal offense. Because West Virginia permits the concealed carry of guns, he has argued that the search was not lawful under the Fourth Amendment, and when the Supreme Court decided Terry v. Ohio in 1968, it attempted to balance the rights under the Fourth Amendment against these types of searches with concerns for the safety of police officers who need to be in contact with folks in situations such as this. Mr. Robinson's appeal presents the issue of how a state's decision to broadly permit concealed carry of weapons may impact that calculus, but obviously there are a bunch of other concerns that come into this. So I encourage all of you to jump in with questions, especially because that will prevent me from exposing any gaps in my knowledge of criminal procedure from Professor Griffin's class this semester, so that'd be great.
No gaps.
And let's kick it off with a question for everyone. I think this case has a bunch of issues, so if we could just go down the line and you could each just kind of identify one particular issue or a couple of issues that are of note to you and that you think are maybe some of the bigger concerns here that either did or did not come up in some of the appellate arguments that happened. You can start with.
Want to start? Yeah. Do you want me to give an overview of the issues, I think, the case?
Yeah, an overview of the issues or maybe an issue that's of particular interest to you.
Yeah, I mean, so without belaboring any of these issues or explaining the way in which I think that they might be resolved at some future point, I think the case is really interesting, even apart from the obvious intersection between concealed carry laws and these Fourth Amendment questions, because it has a lot of the Terry doctrine embedded within it. So some of the questions that the court has really struggled with in other recent cases are the significance of anonymous tips and how to treat anonymous tipsters, the importance of being in a high crime neighborhood, and what it means for law enforcement to use its knowledge of the crime rates in neighborhoods as part of the calculus of suspicion, whether that creates a distributive problem where certain people are constantly the usual suspects. What is often called contempt of cop, or the repercussions of engaging in something like furtive movements, or in this case, a sheepish look, I guess you would characterize the facts as. And then I guess for me, the most important issue about the opinions in this case is how much they emphasize the way in which traffic stops are dangerous for law enforcement officers, and they can escalate. And I think, of course, that is true, and the majority opinion states a bunch of statistics about that. Traffic stops are really dangerous for the people who get stopped, too. I mean, many of you have seen the harrowing video of Philando Castile being murdered at a traffic stop. 50 million people engage with law enforcement every year, and half of those contacts are in traffic stops. You know, that's 10% of all drivers are going to engage with law enforcement in one of these encounters, and some of them end in violence for the people in the cars and not just for the cops. And I don't think the opinion is really engaged with that problem.
Well, yeah, I guess as a practitioner, you know, the most interesting part of this case for me are going to be the practical applications for our practice. And you know, the dissent and Judge Wynn and the concurrence to a certain degree also indicates, you know, exactly what's going to happen is that, as you said, the effects of this rule are going to fall very inequitably on different populations because the cops are going to be looking for concealed carries in African-American neighborhoods and high crime neighborhoods, that sort of thing. And it's, you know, to me, you know, the first case I reread after I read Robinson was Wren, which was the case that Supreme Court upheld pretextual stops, because I see that there's sort of an intersection between the two. And I think there's going to be a multiplier effect that if you can make a traffic stop based on a pretext or a hunch to allow the stop, and then use you know, a suspicion that the person has a gun to conduct the frisk, you're going to be able to do pretty much anything you want, anytime, to anybody that crosses the center line, that has an air freshener hanging from the rearview mirror. And to me, that's a very concerning aspect of this case, and it's going to be interesting to see how it plays out. So that was my first sort of reaction. I read this case is that, man, we already had a problem with the stop. Now we have a big problem with the frisk as well. So I guess we hope to see how it plays out.
A couple things. So first, as I said to Mr. DuBois earlier, my role here is as a bit actor, you know, where, you know, you got the superstars and that's sort of the bit actor. You sort of like nod in the direction and you're kind of in the background nodding. So that's my responsibility. Second, to also commend the board and to support these types of reflective academic endeavors, which I think are really important. And so even though, you know, you're not a large group, I think that this is a particular useful and critical part of the enterprise, and I commend you for doing it. Third, Professor Miller wanted me, he couldn't be here, he wanted me to be sure to say there's no such thing as a Second Amendment right to concealed carry. So I think I repeated that verbatim, and I will stop there because that's the extent of my knowledge, but he wanted me to make sure that that was communicated, and I have done so. Okay, so now I can very briefly answer the question as posed by Trevor. So it's a takeoff from a couple of the things that have been said by the experts on both my right and my left, so I'm going to play the part of the bit player. And here, the interesting thing for me is both the role of traffic stops and then in the context of allowing states and situations in which a state like this is saying that, hey, yes, we know that that it's dangerous for police officers, but the state is making an initial judgment about concealed carry, which I think is really interesting, and ask how the Constitution ought to deal with that type of a judgment. So from an intellectual academic perspective, I think that in of itself is a separate and an interesting point. And then relatedly, on the traffic stops, I also thought about, in the world of Teslas and self-driving cars, to what extent, what role will technology play in helping us resolve these types of tensions? So you can imagine certain types of technological innovations, whether they are with respect to the self-driving cars, whether they're to the concealed weapons themselves, whether they're with respect to identification, right? So what role will technology play in helping us resolve some of those tensions? That is one of the things that I jumped to pretty immediately after reading and thinking about the case, and in large part because I think these tensions in the current environment are likely to get worse without, because of the distributional effects, right? So that seems to be fairly predictable, without an out that is possibly provided by technological advances.
Thank you. Professor Griffin, less than an hour ago at the end of our criminal procedure class, you mentioned that there's kind of this view on like a binary between people's privacy rights and protecting the safety of police officers, but that isn't necessarily something that we should get stuck on. And I think this case clearly presents that kind of issue, and I think a lot of people see it as a binary. Could you talk a little bit more about our hope to get out of that conflict?
That's sort of what, the reason I mentioned that in class, and some of you were in that class, thank you for being here. The reason that I mentioned that is because I think that is the work of constitutional criminal procedure, is calibrating these things and not forcing a choice between, safety and privacy. I mean, those are not things that one wants in our society. You don't want one or the other, you want both of them. And you don't get either one in perfect form, you get some of each. And constitutional criminal procedure strikes that balance, and sometimes it gets recalibrated and changed in different ways. I think in this case, what's interesting about the way that it is changed is because it forces the court to talk about something it probably didn't really ever want to talk about, because it's a completely separate set of political issues that are very fraught, which is whether or not everyone with a gun is dangerous. Before the concealed carry laws interjected themselves into this Terry equation, the question, some of you may remember from criminal procedure, was, is everyone dealing drugs dangerous? Because now drugs and guns go together in law enforcement experience. And if you're in a high crime area or you're enmeshed in a law enforcement situation that involves drug trafficking, law enforcement is allowed to sort of infer that someone has a gun, because drugs are expensive and people protect them with guns, and drug trafficking and violence go mostly hand in hand. When these cases were decided, when the whole idea of having this lesser standard than probable cause and this lesser intrusion than an arrest was promulgated by the court in Terry, there was a companion case called Sibrin that came out the other way, which is you can't assume that someone has a gun just because they're dealing drugs. So these things also change. The way these things are calibrated also change over time. And I think one of the really difficult and interesting things about this case is that the judges disagreed about this and were compelled to confront, do guns always go with drugs? And does danger always go with guns? In which case, anytime there are drugs around, you can frisk anybody you want.
That, I think, reminds me a little bit of some of the experiences I've had in the Eastern District as an intern to the U.S. Attorney's Office. And Mr. DuBois, I think you might be able to talk about what it's like to deal with these felon in possession cases and so many gun cases in a state where gun ownership is relatively common, I think higher than probably the average state. These issues come up a lot. Is it something that your office is particularly concerned with, and how do you handle these types of cases in a state that cares a lot about its gun rights?
Well, we get a tremendous amount of felon in possession cases. It's probably in our top 3 or 4 most common types of cases after drugs or immigration or something like that. And it's a priority of the U.S. Attorney's Office because of the belief that guns go with drugs and so forth. The problem is, you're right, everybody in North Carolina has a gun. And the complicating factor is the North Carolina state laws about gun ownership for felons are pretty complicated. And it's not always clear to the person, even if they've been convicted of a felony. We've had guys who've been convicted of some state felony. They go to their local sheriff's office and say, hey, I was convicted, can I have a gun? And there used to be this automatic restoration of firearms rights in North Carolina, but that didn't restore your federal right to own a gun. So people would go with the blessing of the local sheriff, buy a gun, have a shotgun in the back of their pickup truck, get pulled over, and depending on the criminal history, be looking at a lot of time, 15 years sometimes. Recently I think it was a North Carolina Court of Appeals case talking about, after Heller, whether permanent disenfranchisement for nonviolent felonies was constitutional. Where's that going to go? So all those issues are percolating. Right now, though, I mean, a lot of it's sort of speculative. Generally speaking, if you're a felon in North Carolina and you have a gun, you're committing a serious federal crime. The problem is it's such low-hanging fruit. A lot of our cases are not the classic guy using a gun to rob someone or guy using a gun to protect his drugs. It's a guy who gets pulled over for a traffic stop, is doing nothing untoward with the gun, just has the gun, but yet they're looking at just as much time as a guy who's using it for the classically dangerous uses that I think the laws are aimed at. And those are the hard cases, those are the sad cases, and those are the ones that we really lose sleep over.
Are those kind of an interesting follow-up on the nitty-gritty of the appellate practice here, which is something that we're interested in as the Moot Court Board? Those cases, the sad cases, those also the good cases to appeal. And I'm curious how the public defender picks out a case that they want to try to go the distance and make a change in the law. And I imagine that would influence a lot of the client management and the client relationship as well.
Yeah, I wish we could pick our cases. We can't. I mean, we represent clients, not issues. And it's very frustrating that, we, not necessarily gun context, but in I don't know if you're familiar with the Johnson case from a couple terms ago. A lot of post-Johnson issues falling out, and we had some really good issues that got decided on very bad vehicles, just because they were the first ones up. They were the cases we had to raise to, because it was in the client's interest to raise them. But, you lose that first one because you have a bad vehicle and you're screwed for the rest of the guys. We're not like the government that to a certain extent has the opportunity to decide which issues they're going to push and which they don't. So the bottom line is, and I guess it's pretty obvious, but we represent every client as an individual. We can never elevate a greater number of clients' interest over the interest of the individual client we're representing at any particular time. And frankly, that sucks sometimes because, just on a purely utilitarian basis, the overall, total good is lessened because we can't do that, but there's really no other way to do it. You have to represent the client before you, and that's the only thing we can do.
Can I ask you both a question about something you both said? So on the one hand, you were talking about the sort of the typical cases, or seem to be anyway, in which the person is basically just carrying as opposed to using, right? On the other hand, we're talking about the police officers and their experience of associating guns with crimes, right? So how does one reconcile sort of these two different realities, and how does law reconcile these two different realities? Right? Who should we credit in terms of what that association means and what it should mean for criminal procedure, constitutional criminal procedure law?
Well, I mean, I think it's sad to say, but I don't think there's anybody really at the U.S. Attorney's Office that's asking themselves that question. I mean, I think the ATF, who prosecute most of the gun crimes, I mean, they're like a lot of federal agencies, they're partially stat-driven. And, if the local cops pull over a guy who was a felon, who had a gun, even if he's not doing anything with it, they're going to bring that case, most likely. They're not very selective in that we're going to sort of cherry pick the cases where the guy was using the gun to commit a Hobbs Act robbery, or the guy was using the gun during a drug deal. They pretty much treat all gun cases as pretty interchangeable, pretty fungible, pretty much equally prosecutable. In some situations, it's the sort of innocent possession that's easier to prosecute, because a lot of times in a drug plus gun case, what you'll have is the police search a house occupied by a lot of people. They find some scales, they find some dope, they find a shotgun in the closet or a gun under the bed. Well, whose gun does that belong to? Is that gun connected to the drugs? Was it there already? So like I say, I don't think that question's being asked. I wish it would be asked, because we do have some really sad cases where, honestly, maybe the guy was gonna go deal drugs a week from now. He wasn't then, he just had the gun. But I know for a fact, in my heart of hearts, we have many felons who had the gun for no other reason than it's North Carolina, they wanted to go hunting, and they thought they could. And, but they are prosecuted just as quickly and just as fully as those other categories of gun crimes.
I think there's two different questions, but they're not disconnected. So one is the prosecutorial discretion question about when you have done this kind of a stop and someone has a weapon, are those people going to get charged? And I agree completely that it's very stat-driven, and they're really easy cases, and they're really quick trials, even if they sometimes, as you know, they go to trial because the sentences are so high. But they only take a few days, and they're easy to win because they're status offenses. And so that decision is one decision I think I completely agree merits a lot more skeptical approach by prosecuting offices. The other piece of it, though, is the reasonable suspicion determination, and the way in which thinking that someone has a gun or even knowing that someone has a gun per se is giving law enforcement the opportunity to escalate the encounter that they're having. And that's on the street discretion. It has different repercussions. It may or may not ultimately lead to an arrest or even a prosecution, but it fundamentally allows for an intrusion that would otherwise be impermissible by law enforcement. And as long as the court, as the majority of the court says here, is willing to accept that anyone carrying a gun is subject to such intrusion, that's a real change in the kind of law enforcement tactics, which is a different question than prosecutorial discretion.
And also, just as a legal matter, I mean, I thought, talk about one of the interesting legal issues in the case is, the sort of tug of war between the majority and the dissent between the meaning of armed and dangerous. Is that a unitary concept, or is that a two-pronged inquiry? And, by collapsing as the majority does, into if you are armed, you are dangerous, and therefore categorically possession of a gun is all that the cops need to frisk you. I think that's hard to, let me first off say, I have not read all the, past precedents. I'm familiar with some of it. I think that's a dubious proposition from a legal matter. I mean, I think there's a lot of Supreme Court precedent that would suggest that armed and dangerous means armed and dangerous, that are two different inquiries. And I know cases go both ways, but that's not at all clear cut. It's, I think, a really interesting issue.
Professor Charles, I think this kind of ties into what we've been discussing in terms of the intrusion upon people who are just going about kind of their daily business. But this case, U.S. v. Robinson, at least in the majority, makes virtually no mention of who these folks are, their lives, any racial discrimination that might have been happening because of who they were in the area that they lived in, the high crime area. Do you think that justices on the Supreme Court should be taking account of those issues or making them more clear in their decisions, or is this kind of trying to avoid it and make it very much just transparent and no mention of these kind of hot button issues? Is that a better way to go about it?
Yeah, it's a good question. So there's a law professor in Chicago called Justin Driver who has a law review article precisely on the question of when justices take race into account and under what explicitly take the race when race is the race of the suspect or an individual, of a plaintiff, et cetera, into account, and under what conditions may they do so or not. Because it is a very interesting question where you don't see consistency of practices, where sometimes the race of someone is mentioned, in other analogous similar contexts, it isn't. And sometimes one thinks by the race is mentioned, but nothing is done of it. So, for example, in this particular case, in the description of the facts, we're told that it's a black person, a black male, and a white female, at least with respect to the suspects. And so, what are the conditions under which race ought to be taken into account, and then what can one do about it? Particularly in instances in which there is no clear evidence as to what the relationships would be. But it leads to something that Professor Griffin has already mentioned, in which the reasonable suspicion determination is infected, whether it's consciously or subconsciously, by other types of correlate categories that are either racially inflected or explicitly racial, or racially dimensions, or maybe code 4, right? So that 7-Eleven, right? What does that 7-Eleven mean, or that 7-Eleven in this area? What do you, right? I mean, right? What is that a code for? Is that a code for something? So it's not just about, right, when we're talking about, we talk about race explicitly, but we can also talk about, as Professor Griffin already mentioned, other types of categories that then, even if the court says, well, the fact that we're not going to allow race to be mentioned, or when it is mentioned, we're going to use it in a way to undermine the determination. But other things, as Professor Griffin already mentioned, high crime area, but even beyond high crime area, right? This particular 7-Eleven, or and this particular way, what does a look mean, and to what extent is that culturally and racially and gender, right? So if you ask a black man and he gives you a particular look but doesn't fully answer, but a white guy does it in a slightly different way, and it's a woman versus a man, all of these correlates are really interesting to think about as to whether they lead to an understanding that this is reasonable or unreasonable suspicion. I don't have a clear answer to that. I think these are difficult and interesting questions, but I think when you tug at one, you also pull on the other, and it's not clear that you might be able to limit them, but it's not clear that you can eliminate the worries, especially to the extent that they're subconscious.
Let's talk about this this weird look, which is, I think, exactly what it says in the case, is that Mr. Robinson gave a weird look when asked if he was carrying a weapon. Professor Griffin, does he have a right to remain silent and just give a weird look in this case? And what influence does that have on what the police are then allowed to do?
So there is a series of cases, there are kind of older cases, establishing that police perception that someone is being evasive is not supposed to be sufficient to give rise to reasonable suspicion, because most people are evasive when confronted with law enforcement, and because it is so culturally inflected how law enforcement is going to perceive someone's look. There is also a more recent set of cases about this because of the civil litigation about stops and frisks in New York City. There's great data, for those of you who are interested, on New York City in particular, and growing data about other jurisdictions, but a lot of this is in work by a scholar named Jeff Fagan, who also was involved in the litigation. In New York City, there are two cases, the Ligon case and the Floyd case, and they have good data they also have established that the crime rate has gone down as the stops and frisks have gone down. So that belies a lot of the claims that were being made by the NYPD about stops and frisks. But setting that aside, in 2011, there were 700,000 Terry stops in New York City, and 90% of them were of Black or Hispanic men. And only 1 in 10 of those stops yielded any kind of contraband or evidence, or let alone led to an arrest or a conviction. And most of them were justified by what the NYPD called furtive movements, which doesn't self-define, and your guess is as good as mine. I mean, we all know what that means. It means that they had a hunch that something was up. Sometimes it's described as sort of like seeming to be checking for a weapon in your waistband in some non-specific way, or it's evasive. It's being evasive, or making the look that this case talks about. And they're not allowed to do that anymore, at least not in New York. And that insight is spreading. And just taking that one completely undefined and non-specific category off the stop and frisk menu rapidly led to a decline in the number of stops and frisks. And I think that giving content to the reasonable suspicion standard is the most meaningful way to mitigate the abuse of stops and frisks. And I think that some aspects of this case have content. I mean, there is a corroborated tip about someone loading a weapon in an area where drug trafficking is prevalent. I mean, that, for most law enforcement, and the majority, I think, does a good job of making it seem inexorable that this guy was going to get stopped. But the bit about what they call the holy crap look, or the
Yeah.
I can't remember the exact phrasing the court used, but the evasive look, which in some scholarship is referred to as contempt of cop, basically not doing what the cop wants you to do or answering the question the cop wants you to ask, isn't supposed to, as a constitutional matter, be part of the calculus. And I think there's better precedent now, at least from the civil class actions, for taking it out.
I want to give an opportunity for people to ask questions. We have about 15 minutes, so we have a lot of competitors and people who judge the Moot Court tournament, so, yeah, please.
Yeah, just building off that idea of giving content to reasonable suspicion, I'd be remiss if I didn't bring up the conversation at the police and racing forum that you both helped organize that really stuck with me. You had Professor Friedman and Professor Sklansky, I think, were up, and they were talking about Terry stop, and it was kind of non-controversial the way they were, reasonable suspicion that they're armed and dangerous, reasonable suspicion that criminal activity is afoot. And there were some people in the audience who, to my surprise, and I'm not as surprised anymore after having heard them, just found that extraordinarily objectionable. More so than I think any of us in this sort of legal context would. And, their position was basically, no, stop and frisk is never okay. And I think my sense is a lot of that perception is probably based on what's happened in New York over the years and the offense that has happened in that community and so many others. But I guess my question is in just building up the idea of giving content to reasonable suspicion and also leaving aside whether the court would, because it's a complicated issue. But with Terry now being something like 50 years old, is it time for the court really to find a case that kind of maybe seeks to deconstruct and then build back up Terry?
Alan, do you want to answer that?
Well,
Do you have a good case?
you got one. We're willing to take a run at it. I do think that the time, I don't know if the time's right for the Supreme Court right now. I do think in the Fourth Circuit, the time is definitely right. I think there's an article today, it was either in the Times or the Post, about how the Fourth Circuit's changed and it's no longer the conservative court that people still think it is. But in terms of getting contact,
And that itself is just, I have to say, yeah, it's so wild, because when I was in law school, the Fourth Circuit was like, right, it's like the worst thing in the world.
oh my God, I wasted most of my career in that circuit. Now, like, the young people say, oh, man,
It's so great, right?
You don't know how lucky you have it. Gosh, you actually get a decent panel. But it's funny that, perhaps not coincidentally, the change has really been with the increase in African-American judges, and it is those judges primarily, Judge Davis, Judge Wynn, Judge Gregory, who no longer take what the police say at face value in the way that has historically been done. So I think that's what Professor Griffin is saying. If we throw out if we could find a way to delineate what is really contributes to reasonable suspicion versus what doesn't, and we could find, I don't know if you could do that empirically, I don't know if you could do that doctrinally, but there's some hilarious cases that I think Judge Davis wrote, or I think maybe Judge Wynn, about like all the different reasons police have given for suspicious behavior. In an airport, they walk directly to the gate. Oh, in another case, well, they seem to be meandering and going from gate to gate slowly. They looked directly in my eye and stared me down. Oh no, they avoided my gaze. Anything you did was suspicious and contributed to the calculus, which means that, of course, none of that does. None of that contributes to the calculus. But yet, for years and years and years, whatever story, fable the cops told about why they were suspicious on that occasion was enough for the court. The reasonable suspicion review was really toothless. It was really contentless. In the Fourth Circuit, at least, recently, that's changed. So maybe that is one starting point of trying to really categorize what contributes to the conclusion that crime is afoot versus what is just something that sounds good that the cop can say in the moment to get a judge to, not grant the motion to suppress. I don't know how far down the road that gets you, but that seems to be where the Fourth Circuit's going, is looking at the reasons given by the police with a much more skeptical, jaundiced eye than they have in the past. And frankly, that has resulted in suppression in cases that 10 or 15 years ago would have never been suppressed.
It's also just good policing.
Right.
So I mentioned that 25 million traffic stops a year. When drivers consent to searches in the course of those traffic stops, searches of cars driven by Caucasian drivers yield contraband 4 times as often as searches of cars driven by African-American drivers. And the reason is because they actually have some idea about why they're
Right.
stopping, and otherwise they're just profiling.
Right.
So it's better policing to have a real idea about, it's better use of resources, it's better crime prevention, it's better everything if there's some content to why you're stopping people.
And another thing that I think would help is to give some more structure to the contours of the stop. And that's why it's Rodriguez from a couple of years ago that really delineated the limits of a stop. That, the police cannot extend the stop beyond the bounds for the reason for the stop itself. So, you can't pull a guy over for speeding and then wait an hour for the drug dog to show up anymore. That was a huge case. I don't think people really understood how important that case was, even among the defense community, until it came out. But it's really borne fruit that if the police are going to stop for some sort of generic pretextual hunch on the hopes that they can drag things out long enough to get the guy to either consent or to make a mistake or to do something that will lead to real reasonable suspicion, just that very small structural change that says, no, the stop can't last any longer than it takes to write the ticket for the reason you stopped him, has really, I think, cabined police behavior in a way that I wouldn't have predicted before that case came out.
Professor Griffin, what about the part of Michael's question about what the Supreme Court might do with Terry and similar doctrines coming up? You've warned me before not to read the tea leaves
Nothing.
too much, but...
Nothing. They're not going to do anything with it. That's the answer to your question. So they're reluctant to deal with these issues. As Professor Charles mentioned, they rarely talk about race, even more rarely in criminal procedure than in other contexts. This is not something they're going to confront head on. Be alert for Justice Sotomayor to keep bringing it up, as she does every time she gets a chance. But she's kind of a lone voice on that right now.
Ethan?
First, thanks all for coming and doing this. This is great. So since I first encountered the problem, there was kind of I've had this sense that the government's reasoning with regards to Robinson Field has felt a little bit circular to me in the sense that it's kind of turning Terry on its head. They don't see the suspicious activity and infer from that he's dangerous. They see the gun and infer that makes him suspicious, and so they start following him. And then they use their pretextual stop, but it's my understanding of kind of the whole pretextual stop jurisprudence is that the reason that you allow for the pretextual stop is because they have an inkling that something else is afoot.
No, they can. That's the Wren case that we just talked about. They can. The actual subjective reason why a law enforcement officer makes a stop is totally immaterial to whether or not the stop is valid.
Well, so it's yeah, and not whether or not the stop is valid, but that more that it feels like it's, like I said, that it's kind of turning Terry on its head. And so is that like a constitutional concern in the jurisprudence? Or are there other cases that follow a similar line of reasoning? Because I haven't seen any other cases where the government used that kind of reasoning.
Because of Wren, which is the case that we talked about earlier.
Yeah, and it's funny because I went back and read Wren, and everybody thinks, yeah, and I do. I mean, I think pretextual stops are pretty bad and they really are subject to massive abuses, but it's really hard to find a rule that would bar pretextual stops without just it being just a rat's nest of, how do you get inside the head of the cop? Even though you know with 99.9% certainty why he stopped your guy. But he was speeding, it's just without some kind of it would take a huge empirical project to, either by police officer or by police department or something like that, of a kind that would be beyond the capability of a normal defendant to carry off, to even make a run at that. So I think we're stuck with Wren, but it doesn't mean we gotta like it, but it's just, I was trying to think, like, man, if I was king, what would I do different? And it's hard to come up with a different rule unless you have a lot more data than we've got now, more data than I've got.
So profiling itself is not a legal claim. Doesn't have any, you have to find some other hook to hang it on. And I think that our earlier conversation about you actually didn't have reasonable suspicion, and here are all the reasons why we think that you have articulated some facts as required, but they don't point in the direction of reasonable suspicion. That's a hook where you can hang a sort of quasi-profiling claim. Unfortunately, the court has said that the busted taillight stop is not one of those hooks where you can put your claim.
And, the interesting thing about, profiling is that it's not a Fourth Amendment issue, it's an equal protection issue. And so you'd have to take a run at it, at least that's what the court said in Wren. So you would have to somehow come up with an equal protection claim rather than a Fourth Amendment claim to really get at that issue. And again, it's just practically speaking, it's a really hard thing to do. Maybe somebody will do it someday with, that we've got big data and we can maybe go and see patterns in, stops that we can't see now. But it would most likely get to the court as an equal protection, denial of equal protection than as a Fourth Amendment claim.
Actually, on that, I'm curious if your office's only tool to kind of police the police in this regard and prevent these kind of things is just a suppression motion when they find something, or if you can actually also take some other actions outside of just any individual defendant and try to increase training programs and just liability of the police in other areas, things like that.
I mean, our practice is like 100% at the retail level. I mean, we are dealing with case by case, client by client. What we would love is people who operate more at the wholesale level, law professors, think tanks, law enforcement, DOJ, if they would run some statistics that we could then use to bring to court. So that's, we try to keep up with what's going on in the literature as much as we can, but we have very limited ability to tackle that big kind of project, though we certainly would want to use it as a tool if anybody drops something in our lap. So, anybody got any ideas,
Brandon?
Thank you also again for being here. I had a question kind of following up on the disjunctive between armed and dangerous. I think in reviewing this problem, the question that kept coming up and that was easy to ask of whoever was representing the defendant is, okay, then does dangerousness depend on the state statute at issue, whether you're in a concealed carry state or not? To what degree should that matter, and to what degree should the Fourth Amendment vary based on different state law?
I mean, I could be wrong about this because I haven't thought as deeply about this case as I should have. I mean, I thought this case, like so many cases on appeal, was all about framing. And, the majority framed this as an officer safety issue. The dissent framed this as this is a, intersection of Second Amendment and Fourth Amendment issue. I mean, I think the whole thing about whether concealed carry is legal or not doesn't so much go to the dangerousness as it does to the reasonable suspicion. But again, I go back to what I would want is empirical data of, in this state, I think it's important because states with concealed carry laws presumably have more people carrying guns than states that don't. And so are there variable rates of violence in those states? I don't think this is true, but, you know, Robert Heinlein, the science fiction writer, said, an armed society is a peaceful society. Well, I mean, that's subject to probably empirical testing, you know? Do more guns equal more violence, less violence, the same violence in states that have different kinds of laws? So I don't think it's so much the legality of the thing, it's what a state's laws show about the relative dangerousness of the populace who may or may not be carrying a gun. I'm not sure that makes any sense, but that's sort of how I would take a run at it. I think the dissent makes the point that in the past, when there were very few permissible ways to carry a concealed weapon, when a police officer saw someone who seemed to be carrying a concealed weapon, it was a reasonable assumption that they were breaking the law, that they were willing to break the law, that they were, and therefore the next leap is, well, maybe they were more dangerous than someone who is not willing to take that step of living outside the law. You know, in a state that has a broad concealed carry law that has a lot of people carrying guns, that first link in the chain is broken. So, you know, maybe they're not as dangerous. I don't know. So those are just some of my stabs in the dark at thinking about when I was reading the case.
Other questions?
I think there's also sort of doctrinal answer to Brendan's question,
Please.
and I agree completely. But Michael correctly articulated the two-step Terry inquiry, which you guys know as well. Is criminal activity afoot? And then you can stop and question, and is this person armed and presently dangerous? Then you can frisk. And I think that definitely, as you know, the Fourth Amendment is not coextensive in any way with the state law. But that first question is answered differently in a place where the only suspicion is a right. So that if the criminal activity that you suspect is afoot is the gun possession, that's going to be different in different states. But here the stop was based on something else. And then the gun is the thing that prompted them to imagine danger. And I think the danger calculation probably stays constant as far as law enforcement's perspective on the jeopardy that they might be in across jurisdictions. But that first piece of it, but for the tip, the high crime area, the pretextual traffic stop, the other things that allowed them to actually make the stop, it would have come out differently, I think, given the concealed carry laws. Because if the only thing that is afoot is possessing a gun, and it's not a crime to possess a gun, you've missed the first step. So I think that's the way that it affects the calculus, but probably not as much the dangerousness thing.
One thing I was going to mention, you guys are probably already aware of it since you were up to speed on it, but as I was looking at this, the Intermediate Appellate Court in Illinois, in a case called Horton, that came out like a week or so ago, just came out the other way on Robinson and suppressed a stop based on the theory that, you know, concealed carry is legal in Illinois, and that the police officer that didn't have there wasn't a reasonable suspicion that the person was armed and dangerous. And so it was a sort of interesting case to read after reading Robinson, to see that this case can definitely come out different ways depending on how you frame and view the issue.